very much for the comments. I propose that the presenters each take 2 minutes, not long, just 2 minutes, to respond to probably just a fraction of the comments, because otherwise we will not have time for the audience. So I have already 3 names down from our first improvised round of questions. You're on the list, and everybody else will have the chance to. So presumably there will be lots of questions, so let's keep this round short. There will be more chances to respond. In which order shall we go? Would you like to go first, because she started with your paper?
Jeżeli chodzi o ustalenia
as to roundtable negotiations and discussions about persecution of communist crimes, I must say very frankly that I do not remember that there were some important statements that we are going to persecute these crimes and we are not going to persecute these crimes or prosecute these crimes. There were no clear declarations of the sides of specific legal steps, how to adopt laws, how to amend laws. In my research, I found minutes of a sitting of the Commission for Justice and Legislative Committee, during which, on the 24th of March 1990, they presented a draft of the law on prosecuting these crimes. And the position of the committee, or the Committee of Justice, was as follows. The draft was about the following thing, like prosecuting the crimes was to be limited only to offenses to the 31st of December 1956. And the draft of the law was submitted to the sitting of the Parliament in 1991, April, and justification of the draft was the following. Even after the 31st of December 1956, after this date, there were similar offenses committed, but the year 1956 is a very important period and closes a certain phase of especially negative activities of Polish authorities, which is called in the trade literature the Stalinist period, the Stalinist era. So that is why it was to be the seizure, this end of the era. And the question arises, a basic question, whether after 1956 there were no communist crimes. Let me remind you of 1970 in Poland, 76, 1980, 81, the martial law. What about these offenses? What about these deeds? So when I come back to your question, if there was no clear declaration and clear arrangement during the roundtable talks, even the first laws in the 1990s pointed to the direction of the legislator. So that's all from me. Thank you.
Thank you very much. Agata?
Yeah. Thanks very much, Lavinia, for the comments. I forgot to talk about the Rulli report extensively, but what also I forgot to mention in the paper was the 2006 initiative by the Romanian president to institute this research into communist crimes, and came out with a very extensive document, and sort of the critique that came out after that in terms of, does that mean everybody's absolved of anything or what have you? And of course, this too needs to be taken into the context of Berisha's comment in the 1990s about, this part of this should be left for the historians, namely the past, and that we're all guilty, and we need to, yes. So I think that's very interesting. Yeah, I think that's all I really wanted to say. Thank you very much. Yeah.
Thank you, Lavinia, for your thoughtful comment. Actually, you made my point, because I'm always trying to look at the historical context, to put things in context. And in that case, I think that that although the Jewish DP community was, in a sense, a unique one, it also was a part of or an integral part of the post-war transitional period. And after all, the majority of the Jewish DPs were East European Jews. So in that sense, they were part of a much broader proceedings that took place after the war. And as for the past and the future, you know, they saw themselves as a bridge connecting between the past and the future. So their lives, they managed their life on a transitional bridge, but they were always looking back in order to make a better future, or to reconstruct the future of the Jewish people. In that sense, they were the trials, the legal proceedings were exactly managed from this perspective, managing the past in order to make a better future for the Jewish people. Thank you.
Thank you. All right. We were already on the list. Let me just take down the name. Okay. So I propose that we group questions, right? Thank you. Kasmin is first, and then Elazar, and then this gentleman.
Is this on? Yeah. All right. Thank you very much for your presentations, and I have comments and questions for Rivka and Agata. One of the questions for Rivka, where would you place in the process of nation building these trials, or these quasi-trials? And a more, let's say, technical question is related to what legal framework might the judges use at that time, or they might have not used? I mean, what was the legal framework or the system of law that they applied when looking at these cases? And here it comes to my mind also a level of similarity with a series of very strange trials which took place between 1933 and the Nuremberg legislation, which were trials brought by Jewish people in already Nazi Germany against Nazi perpetrators. And there were trials which succeeded. Strangely enough, it was before the Nuremberg legislation, in that period of time. And I would say, because I'm very interested which legal system, or in which legal system the judges have been socialized as lawyers. Because it might be this fact that even in some contexts, even an evil law or a certain legal system can still provide some form of protection being creatively interpreted by lawyers. So this would be. For Agata, thank you very much for it. It was very, very interesting. I'm very interested in this part of the relation between law and archives, or law as archive, or law as a visual archive. which is very much related to a, I would say, an old tradition of law understood as speculum juris, for instance, where the first forms of legal treatises were called speculum juris, like this kind of mirrors of the law. So there always has been, there always are some forms of visual aspects or visual imagery in the presence of the law. So looking at the picture, which was the photo, which is really strong, it came to my mind a small passage from Walter Benjamin, saying in the thesis on the concept of history, saying that now and then, well, then and now, they come together in a flash. And it's what my question is, to which extent this memory of political dissidents in Albania, for instance, it's present? To which extent it is present in the public eye nowadays, and how it can affect the political spectrum nowadays. And I think Albania, it's a very, very interesting case. Well, coming from Romania, we don't really know much about Albania. I mean, during the Yugoslavian war, the war in Yugoslavia, that started to circulate some jokes about Albania and Romania. That's one of the things, that the relation that we have about Albania, making jokes about them. And also, you see always this presence of pillboxes. But I would like to, I don't know, I think that there is also some form of misconception of seeing Albania this kind of forsaken country. And I would make here the distinction, for instance, between Hoxha and Ceausescu. Hoxha, he was pretty much, and that's the true horror about the communist terror there, he was pretty much a communist intellectual. He has been present, he has been trained in France, he had traveled a lot, he wrote books which weren't just, I mean, there were this kind of theoretical interventions inside the framework of Marxism. So I would say, to which extent do you think that this presence of, I don't know, some form of intellectual sophistication comes together with pure terror? And how would you place this somehow? Okay, thank you.
Thank you. Elizabeth is next. Wait for the microphone, please. Thank you.
Thanks. Rivka, I have a question actually on the limits of guilt in that regard, and whether there were people who were found innocent, and whether mere affiliation was a guilt enough, or whether behavior impact the question of guilt versus innocence in that. Among people who were identified as collaborators, is mere identification was adequate for finding the individual guilty, or were the behavior of the individuals as a person in that role mattered as well? And were there people who identified and were found innocent, or where everybody was found guilty?
Po polsku będzie.
This is going to be in Polish, Andrzej Kopczyński to Rivka. As regards the trials in displaced person camps, the persons deemed to be collaborators, did they later found problems in settling down in the US? Because some of them might have been deported from the territory of the US. So were they allowed to settle down in the US, and were they allowed to settle down in the state of Israel later on? Thank you.
All right. I would like to respond first. No, we can't take all the questions at once. Thank you. Who of you would like to respond?
Should I go first? Right. Okay.
Thank you.
Thank you, Kosim. Yeah, for your questions. I actually really like the question that you gave about the judges, because I think that is so important. I very much like this idea of an image being like a flash, the then and the now. I think that's wonderful, and that's a very important way to then try to address this question of political dissidence. What I have found up to this point, what I think in relation to how significant is it present there? Oh, I do think it's present there, but it's similar to the legal narrative. There's no, for lack of a better word, reference point to hang it on to. So I don't necessarily see it as something that's static, but it's uncoordinated, yeah. And that's the result of the kind of regime it was, I think, and that. So that's as much as I think I can say with respect to that, and it's something that does intrigue me, and I think that's why I keep looking at this. I think you could also say the same with respect to the bunkers with the pillboxes, because this is also another image that you see when you go. You know, there used to be some 800,000 bunkers constructed in this country, and this was only in the 1970s. It wasn't, you know, and I think that that's very indicative of the kind of regime, if you like, the mentality that characterized Hoxha. And you go to these pillboxes, and they're everywhere. You stumble over them. And funny enough, with these bunkers, there were so many of them, nobody could destroy them. They didn't know how to get rid of these bunkers. So they employed persons from the Roma community who were able to found a way to destroy the bunkers by lighting up a tire. You plunge it into the bunker, and it just blows up. But anyway, the remaining ones, in terms of, if you like, moving forward with the now and the then, have been integrated now into restaurants, meeting points. I'm interested to see what they do with this pyramid in Tirana, which apparently is supposed to be torn down, but I don't know. That's another image. Okay, you talk about intellectual sophistication and pure terror. When I've been working in the archives, what's very interesting, and this is in relation to the trials, once again, I'm missing a reference point. This is, for me, very silent, what's silent in terms of what is the law, what was the law in Albania. And I think that a lot of assumptions have been made with respect to, present-day critiques in terms of judiciary, the legal system, without any sort of reflection on what was it. But what does come out, and this is then in overlaps with who Hoxha was, I think, is that, and this is something that needs to be researched, but I don't know how accessible these particular archives would be, for example, probably in Belgrade, yeah, is the input, at least until 1956, until Hoxha decided to turn his back on the Soviet Union, is the input you have from the Yugoslavs in relation to approaches, ideological approaches. I think there was a lot of cutting and pasting on the part of the dictator. That's the feeling I get, rather than really understanding what it was all about, and then recrafting it as a sort of like a messiah-like, similar to what Lavinia has written about in terms of Ceausescu, sort of sultan-like approach and almost religious in the form of the pyramid that, okay, it's just in Tirana. So I think that's something that does need to be explored, and whether that was then the kernel that, or the link to a pure terror. Yeah. Does that answer your question? Okay, thank you.
Thank you for your question. Oh, yeah. This is for Cosmin. As for nation building, usually the issue of nation building is connected to a state. And we are not talking to a state, we are talking of a transnational entity, the Jewish people. But they really thought about a way to make a better future, or to correct what the collaborators have done by their behavior. The Jewish DPs, although they were a very small community, or relatively small community, they perceived themselves as the remnants of the entire Jewish people. They saw themselves as the chosen community of the chosen people. So they thought that they had a very heavy duty to think of the future of the Jewish people. And these trials against the collaborators were part of it. So it's not strictly nation building in the sense that we usually talk about, but sort of nation buildings. Your second question is very interesting, the content of the legal trials. The records show that there were two different legal systems. One was what I call the law and order legal systems. There were groups of people. They need to be to maintain law and order, to watch discipline. So this was a kind of regular legal system. The most interesting legal system is that of the trials of Jewish collaborators. So they had a statute that defined the offense as harmful deeds against Judaism. It defined the procedures and the penalties, or they called it the penalty that all of them were with social character, not imprisonment. Every one of the judges had a legal baggage from his country of origin. So it was part of East European, mostly procedures. It was part of it was a consequence of the nearest future of the Holocaust, of their experience as Holocaust survivors. And part of it, which I have a bit trouble to explain it in English, leaned on a very ancient Jewish law, which is called in Hebrew Din Moser. It's the law of informers. So it's a very ancient law, a religious law, that usually was used against informers to the Jews who informers on their Jewish fellows to the Gentile authorities. So basically, I'm trying to establish a connection between this ancient law, the law of informers, to the trials that in the Jewish DP. So it was a mixture of different legal systems. I hope and now Elazar. There was a heated debate in the Jewish DPs, as well as in the Israeli parliament. What will be the accusation? Whether the mere fact that one was a member of the Judenrat or member of the Jewish ghetto police, or the fact that he was a capo, is this define an accusation, an offense, and thus he should be put on trial, or the court has to look at his behavior. And this was a very significant. They decided to put on trials according to the behavior of the person, and this was a very significant step for them, for the public discourse, because it made possible for a capo to be a good capo, or to be a good policeman, which the public discourse couldn't think about. Because the public discourse took the whole collaborators as traitors to the Jewish people without any differentiation between the behaviors. The legal discourse was much more nuanced and was able to find different degrees of wrongdoings. So no, not everyone was found guilty. There were many who were found, they were acquitted because they follow strict procedures, and the verdicts were based on testimonies. Once the testimonies didn't establish a concrete base for conviction, so the defendant was acquitted. And as for the question for immigration to the States or for Israel, I don't know much about immigrating to the States, but I haven't read anywhere that Jewish survivors were deported from the state. I don't know any case, such a case. But as for Israel, this is very interesting because every verdict in the DPs was published in the Yiddish newspapers. There were tens of Yiddish papers all over Germany and Europe at all. So any conviction was published in the Yiddish newspapers, and it was transferred to the agencies that helped Jews immigrating to Israel. So this was part of the thought that those who found guilty in collaborating with the Nazis were not fitted to take part in the Zionist project. They were not. They didn't get any assistance to immigrate to Israel. But some of them managed to come to Israel. Some of them were put to trial once they got to Israel. Some of them choose not to come because they knew that once they will be there, they will put on trial. Thank you.
Thank you very much. We have a fairly long list of 6 people, and so we'll take 2 rounds of 3 questions, and please have the questions and the answers reasonably short. We will have a coffee break so you can answer the rest of the questions. I would just like for all of us to hear all the questions. Mark is next.
For both Agata and Rivka, I'm wondering whether there was much concern either at the time or thereafter, time of these trials, with the sense of the retroactive character of the law in both cases. I ask this not in terms of just the legal issues as such, but the larger normative moral discussion about whether these trials were fair to the defendant. And just to explain why anyone would have those concerns, with respect to the Israeli cases, or sorry, the displaced persons cases, there was no crime of deeds against Judaism. There was no crime of treason against the Jewish people at the time these events occurred. No legal system had enacted any such offenses. You said that it would have been inconceivable to rely on the German code, but the German code at the time had the crime of complicity in murder, in which most of these acts would have been encompassed. Polish criminal law as well, for that matter. And prosecuting on that basis would also have enabled the prosecutors to refute the claim of German judges that they simply had to follow the rules laid down, because the rules laid down would have concluded the law against complicity in murder. With regard to Albania, the question would be, did the crime of genocide exist under Albanian law at the time of the events? Even if Albania had enacted the Genocide Convention, it would have had to incorporate it within domestic law and include, among the protected groups, intellectuals. It's inconceivable to me that that could have happened. And finally, with respect to Marcin, I can't help but wonder whether the crimes against humanity, which includes the crimes of persecution and degrading treatment, were not seriously considered, because battery and assault definitely involved degrading treatment, and that would not, and crimes against humanity are never subject to prescription.
Tadeusz Szumski. Ja nie jestem...
Tadeusz Szumski. I'm not a lawyer, but I have a technical background, and as a technician, I'm very much attached to details. But from your deliberations, I see how difficult it is to try communist offenses. And to my mind, in law, we need to define the offense first and persecute it later. So my suggestion to Lavinia is as follows, because Lavinia was our commentator here. Was Nuremberg and Nuremberg trials not a fair attempt to persecute the Nazism and the Nazi crimes? And if so, communism was not subject to any trial whatsoever. For instance, in Latvia, there is no way to come to terms with communists. In the EU, we have this human rights court in Strasbourg, and they turn a blind eye on cutting and the massacre of slaughtering in excess of 20,000 prisoners of war. So maybe a time has come to set up a new Nuremberg court to come to terms with communism. Thank you.
I have a question to Marcin, and I will ask it in Polish, if you mind, if you don't mind.
This differentiation between offenses punishable up to 3 years and beyond 3 years of imprisonment is very significant, features very significantly in your line of reasoning. And my question is, what type of offenses were punishable with 3 years or 5 years imprisonment? Because I'm not a lawyer, so it seems to me that this is like differentiation between grave offenses and not so grave offenses. To me, it would be really interesting what kind of suffering, what kind of wrongdoing was defined by the legislator, and what kind of suffering deserves re-examination and which one doesn't deserve any redress or re-examination years after. Thank you.
All right, who would like to respond first?
Lavinia, you start the question. Okay.
I started last time.
No, you start now. I'm just joking. Okay.
Thank you very much for the question. I want to say yes, that it did have a place within the pre-1993 code, but there are limitations, as you have noted, with respect to whether it would ever be even made effective, and also within the context of the series of trials that were arranged in that critical period. One of them, this is before the Albanian opposition trial, being referred to as the Albanian Nuremberg trial. But it is something as well when you speak to people working in this area about genocide, is the surprise on the part of lawyers to find that actually there is a provision in the form of Article 73 in the present-day criminal code, and there are very ambiguous answers in relation to what occurred prior to that, and I suppose that relates back to the previous question in terms of there's no reference point here, what's happening with the law. So, you know, this is something in terms of what I mean, the legal system, who was within the legal system, if you're looking at a quality of a law in the legal system, if you like. And that's certainly something that will be a point that I'll be further looking into in relation to developing this paper and work. Okay.
Thank you. As I mentioned earlier, this is I'm only at the beginning of my research, and I always have the feeling that I am inventing some theories. No one have ever written about this subject, and I base my sources are primal records that no one ever touched them, that no one ever read them. I don't know why. I have no explanation, because the life of the Jewish DPs are now have been researched very thoroughly. Only their sort of legal life has been neglected. I have no explanation. So I have to think about what you have asked. So if it's okay with you, we could continue it a bit later. Thank you.
Tak, w pierwszym rzędzie.
Well, in the first place, I fully agree. Yes, as for crimes punishable with 3 years of punishment, they were entirely forgotten, not to be persecuted ever again. Crimes punishable up to 5 years of imprisonment, practically they could be prosecuted, but in real terms they were never persecuted, because they were believed to be prescribed after 1995. And even if the Polish legislature has never provided for amnesty, the prescription was an accomplished fact. What kind of offenses were involved here? Punishable with imprisonment of 5 years, unintentional manslaughter, and here the perpetrators of battering to death of young Grzegorz Przemek, a notorious case in Poland that you alluded to, sir, they were tried for unintentional causing of someone's death, and this is punishable only up to 5 years of imprisonment. Another provision, inciting suicide, again punishable with imprisonment up to 5 years' time. Then another category, if someone deprives somebody of his sight or hearing powers, or unwillingly causes heavy bodily injuries, is only punishable up to 3 years' time of imprisonment. And mind you, in the Polish legal system, any heavily body injury, incapacitation, any other wrongdoing was immediately considered to be not to be persecuted, battering, harassment. This was all considered to be not grave enough and to be pardoned and forgotten. So the category of battering, for instance, was believed to be so petty and so universal and ever-present that there is no point in regulating it. And in other cases, more grave cases like unintentional manslaughter, they were, of course, theoretically punishable up to 5 years in prison, but for obvious reasons of legal obstacles and of prescription rules, they were never persecuted in practice. So these were very grave categories, as you can see. Thank you.
Thank you. Suppose that we take the questions from the two people who have not asked questions yet, because you had, in fact, 3 questions. Who were this gentleman and then Nadia, and then if you can, brief questions and brief answers. Please go ahead.
Thank you. Andrzej Rzepliński. I have a comment to your comments. I really don't know what do you mean saying Eastern Europe. If I could understand that this in your mind is former communist countries or communist countries, if I'm right. So China is also Eastern European country, or Vietnam, or Cuba. If not, definitely Czech Republic or Slovakia or Hungary or Poland is not Eastern European country. And also western part of Ukraine is not Eastern European territory. It's something different story, completely different story. No. Albania is not Eastern Europe. I know Albania very, very well. It's not Eastern Europe. If it is geographically, also Greece is Eastern Europe. So we should be precise. And you spoke about prosecution or lack of prosecution of communist crimes in Albania with passion, and you would be very good public prosecutor, but this is very hard to prosecute those who were personally not involved in crimes, in communist crimes. I would not be very enthusiastic with prosecution of, I don't know, Goebbels' wife or Hitler's wife, if would they survive the
Do you have a question?
war.
Do you have a question? Or is it just comments?
This is my comment. And
no, I'm sorry, just questions, please. We're running out of time.
I have no time to be there longer. So.
Thank you very much, Nadia.
Okay, this is just a very quick question, but it might be a complicated answer, so feel free to be brief. I'm just interested from Rivka, what accounts for the obliteration of the memory of these prosecutions from Israeli memory or Jewish memory more broadly?
You mean as regard to these trials in the Jewish DPs?
Yeah, did you say that they were obliterated from the memory? Not
they had. It's very interesting. There are no traces of this trial, of the DP's trials in the memory of the Holocaust in Israel and in the entire Jewish people as well. In the legal proceedings that took place in Israel, they were talking obviously about the same facts, about the same people, about the same Holocaust, about the same time, and there is not even one legal proceeding that I have read, and I read many of them, or almost most of them, and no one ever mentioned these proceedings. So far, I have no explanation for this. This is something I have to think about, because it's. I think that the fact that they have no trace in the Israeli memory, has or bears a very deep significance. But I have to think what kind of significance it is.
Thank you very much to our panelists and the commentator for this very interesting panel that asks us what are crimes to whom and how they get to be crimes. I gather that there is coffee and possibly something a little to eat outside. The next panel will start in exactly half an hour. We shall try not to be late again. Thank you.